Thanks, Brent. Good afternoon, everybody. I think I've met some of you. Others I look forward to meeting in the future. I'll actually be up your way next week, so hopefully we can bump into each other. As Brent mentioned, we're located in Research Triangle Park, and we sort of specialize in entrepreneurial companies, particularly as they are spun out of universities. I think we've worked with over 100 universities and nonprofit organizations in terms of licensing out their technology to our clients. So we've really got a good view of what people are experiencing as they work at building a company with university technology. What I'd like to discuss this afternoon, or as Brent mentioned, some of the things that we've seen before that we try to help our clients navigate around some of the pitfalls that you might encounter. Let's see. It's this. So I assume everyone can see these slides. Okay, I see some nods.
No, we can.
Yeah. So some of the topics we're going to discuss are, one of the biggest ones is the protection of intellectual property. Most, if not all, of university spinouts have some sort of intellectual property involved, whether it be patents, copyrights, or just know-how. We're going to talk a little bit about dilution, the concept. We're going to talk about the failure to read contracts, transitioning into the company, meaning transitioning the technology and the assets into the company. Failure to account for stock vesting for founders. We're going to talk a little bit about the concept and the importance of it. We're going to talk about money coming in and money going out. We're going to talk about equity issuances, particularly as it relates to family and friends and seed investors. We're going to talk about then the next step of raising venture capital. A little bit about failure to document, failure to keep good records, and failure to listen and delegate. So that's sort of the topics we'll discuss. And if anyone has any questions along the way, by all means, speak up, and we'll also have time at the end, I believe. So this is an anonymous quote: "Starting companies is like having babies, fun to conceive, but hell to deliver." Of course, I've never delivered a baby, but my wife has, and I know that that's very difficult. The first topic: failure to protect intellectual property. As I think we all know, the main worth of the business, aside from the people talent, is largely the intellectual property that is brought into the company. And that's whether or not the transfer of the IP is from a university license, or whether the founder has his or her own background IP that they're contributing to the company. The important part is getting that to the company. We usually think of IP as patents, copyrights, and trademarks. There's other things to consider: proprietary know-how that doesn't amount to patentable inventions, but is nonetheless proprietary in that it's not known in the public domain. And of course, trade secrets, which is a somewhat higher standard to achieve on non-patentable technology that is largely statutory driven. The number one key in protecting your intellectual property, of course, is always entering into non-disclosure agreements with third parties, but that includes, visitors to your labs or your facilities, as well as all your employees. Bottom line is the failure to take steps to protect IP can be a fatal flaw. This is I guess a marketing plea for intellectual property lawyers. I'll say out at the outside, outset that we are not patent lawyers, but it's always good to talk to an IP lawyer. I realize that the technologies that is coming out of the university is likely in almost all cases being protected within the university and their patent council. But in terms of, as you grow your company, you're going to develop your own IP, and you always need to remember that that also needs to be protected, and that's not going to be necessarily done by the university patent council because it's IP that the company develops itself. So let's talk a little bit about employees and intellectual property. You always want to make sure that all employees and consultants of the company sign an agreement that is very clear that any intellectual property that he or she generates while they're providing services to the company is owned by the company. Without those agreements, companies can get in trouble in terms of who owns what. So we want to be very clear. We have all our founders and all our our company employees sign proprietary information assignment agreements to make that very clear. And of course, we already talked about non-disclosure agreements that also protect the IP. Bottom line is, you want some paranoia here. You want it to be healthy, but as we mentioned at the outset, this is the intellectual property is the bread and butter of the company. So you want to make sure that you protect it. Here's a quote. Our consultant provided their standard form that they'd use 1,000 times before. The business terms match what we had discussed, and the rest just looked like boilerplate language, so we signed the agreement. Well, believe it or not, that sounds like a silly statement, but we've seen that before, where a consultant comes in, the company signs an agreement without really thinking it through or having legal review of it, and the work product part of the agreement doesn't expressly say that all the work product belongs to the company. It's very important that consultant agreements, employee agreements, etc., have that type of language. So we haven't talked a lot about trademarks, but obviously trademarks can be very valuable. Folks sometimes believe that, if you get your company registered in the state of Virginia or Delaware or wherever, and you get a domain name, then you have a trademark of that brand. And the simple answer is that you do not. If you believe that the name of the company is of value, and you want to get it trademarked, it's very important to go through that process to get it registered. There are some common law trademark laws, but to really protect your trademarks, you need to go through a trademark attorney so they can register it with the Patent and Trademark Office in the whether that be in the United States or outside the United States, depending on what you think the value of that trademark is, and that goes for your products, product names, etc. Okay, let's switch gears a little bit and talk about dilution. So, let's just assume that there's two founders, and things are going good, and they say, well, we'll split the equity 50-50, which is common, but we see a lot of entrepreneurs get very nervous about dilution. And what dilution is, when you begin to raise capital, obviously the investor is going to put money in, and they're going to value the company at a certain amount, and they're going to get a percentage of shares of the company that represents the value at that point. So that would naturally dilute the founders into something less than 50%. And, we have, not all the time, but often we have founders that get very anxious about that because, they don't want to give up, a piece of the company, unless they have to. But the bottom line is that, that's the only way usually to advance the company. So as this slide illustrates, you can have all the cupcake or a larger slice of or a slice of the bigger pie. And what we need to explain to some of our founders that, that cupcake may be worth very little. And yes, you have 50% of it, but at the end of the day, if there's an exit, it's going to be much smaller than that slice of the larger pie, that is far less than 50%, but far more valuable. So it's just something sometimes founders need to kind of get over that hump with. Okay, failure to read contracts. Believe it or not, people do sign contracts that they don't read. I just had a case this week where a founder signed a consulting agreement for some software development work. And the relationship wasn't going so well. The client had invested a good sum of money in the services, and some of the software was developed, but it was going nowhere. And so his thought was that I'll just terminate the contract and have someone else step in right where the other guy left off. Unbeknownst to him, when he asked us to look at the contract after the fact, it clearly said that upon termination, all the licenses to the software revert back to the consultant. And so if he were to terminate the agreement, he would have to start from scratch on the entire agreement. So that's just an example of something that we could have addressed up front. If there were, for example, to add a provision that if there was a termination because of the consultant's breach, that the license would continue. That's not an unreasonable request, and something we could have helped out up front. Again, either a savvy individual in the company who has a little bit of experience in reading and issue spotting contracts, or outside legal counsel should read all agreements just to know. I mean, you're going to have to take some level of risks when you sign agreements, but you at least want to know what you're getting into. Keep copies of all signed agreements. A lot of times we have clients with not good record keeping skills, and we ask for the signed agreement and they can't find it. We've talked about beware of template terms and conditions. You can bet that any consulting agreement, services agreement is going to have a very limited liability base, as it relates to the consultant. And in some boilerplate language, it actually requires the company to indemnify the consultant for its negligence, which sounds crazy, but it's sometimes in there. And to point out, when sales folks are motivated differently, that's not a good or a bad statement. It's just that sales folks' metrics are to bring in the sales, right? They don't care what the agreement says necessarily. They agree what the dollar amount says. And so for the companies that are able to relatively quickly generate sales, it's very important to educate the sales force on these types of pitfalls. All right, transitioning into the company. So university employees, typically our founders continue to work for the university. And so there needs to be a clear demarcation of when you're working for the university and when you're working for the company. And obviously, any conflict of interest that needs to take place within the university itself needs to be addressed. But you need to be very clear about when you're working for the company using company resources as opposed to university resources, because again, that goes to who owns the work product generated by the founder. We've seen folks get in trouble with sort of blurring the lines of when they're working for the company, when they're working for the university. So it's best to be very careful about that. Work with the university to make sure they're on board on these types of things. The founder's roles and responsibilities should be spelled out in writing. What are the founder's responsibilities? What happens if they don't fulfill those responsibilities? And we'll talk a little bit about vesting of equity as it relates to founders in a little bit. Be aware of, as you start to grow and bring on folks, be aware of any non-competes that are out there that a prospective employee might be subject to. There is some recent proposed regulations that would outlaw non-competes altogether in the United States. They have not been enacted yet, but there's a good chance that they will. So hopefully that, in my view, that would be a good thing, to be a free market and to not have non-competes out there. But as it stands today, there are non-competes, and you don't want to hire someone who is subject to a non-compete because you're hiring potential litigation with potentially a bigger player who has a deeper pocket. And we talked about employees signing proprietary information assignment agreements. Okay, failure to account for stock vesting for founders. So we almost always recommend that founders have vesting on their founders' shares. And what that really means is, upon grant, you get 50%. Let's go back to our example. You get 50% of the company, but those shares vest typically over a 3 to 4 year period. And what that means is if the founder either leaves the company, does not fulfill its obligations with respect to the company, then any shares that are not vested at that time can be repurchased by the company at a nominal value. So in other words, the founder would lose a certain amount of shares. And the reasoning behind that is to protect the company, but also to protect the founders from each other, because you don't want to sign up to do something and have someone decide they're going to do something else and walk away with 50% of the company. Furthermore, investors, if you don't have vesting in place when you form the company, any sophisticated investor is going to require that you retroactively add vesting to those shares, because they don't want the founders, who they're really investing in the IP and the founders. They don't want the founders to leave the company either. So it's sort of a golden handcuff type of thing. One note, this is a little bit into the weeds, but it's important if there is vesting on the stock, that the founder submit what's called a Form 83B to the IRS. And what that really does is protects the individual from recognizing income and therefore income tax on the value of the shares as they vest. Typically, when you issue founder shares, they're valued nominally because there's no assets to the company. The value of the company is nominal. But if a portion of your shares vests, let's say a year later, they vest without the 83B, they vest at a value based on the company at that time. And so that would be ordinary income to the individual if they don't file the form 83B. With the 83B, it's deemed to still be a nominal value, and you don't incur that tax until there is a further exit with respect to the stock. Typically on vesting, there's an acceleration upon a change of control. So, if the company knocks it out of the park in 2 years and someone comes up and says, we want to buy you for, $15 million, rest assured that vested stock, that the stock that's not vested would automatically vest. So you don't lose that 50% piece at that point. Okay, money coming in and money going out. A lot of times our clients will initially going on friends and family rounds. That's okay. That's great. But it's very important that all those relationships are documented from a legal perspective as if they were not friends and family. The worst thing that can happen is you have a friends and family round that somehow goes awry because there was not a meeting of the minds on certain aspects of it. It's really an easy way to lose friends and even family, even though you can't really lose family, but those relationships, it's just, you really need to, at the outset, act like a company, as opposed to individuals who have a great idea and are going to knock it out of the park. It's very important to, keep financial statements, to meet with accountants, to meet with lawyers, and we'll talk a little bit more about record keeping, and those things need to be done from the outset. You need to plan for success, and that planning for success starts at day 0. Okay, equity issuances. We're an early stage company, so we're just priced everything at one cent per share. Well, that's okay at the founders level, but let's take the case of, you form the company, you issue the shares, you license in the technology from the university, you do some development. A year later, you want to bring on a new founder, or you want to bring on a consultant and grant them shares instead of paying them money. Well, at that point, the value of the company is no longer nominal. It's got a value to it. So any stock that is issued that is not issued for cash or fair value will be taxable to the individual. So we have a case right now where at another university, one of the co-founders was prohibited at the time of creating the company from being a founder of the company based on certain other things that were going on within the university. All that was cleared up. Now they want to issue shares to this founder, but now that, it's been 3 or 4 years, and there's a significant value to the company. So, there's the way. So if we were to issue shares to him, he would have income tax based on the value of those shares without cash to pay that tax. So, you could do a couple things. You could create a stock option plan. A stock option plan grants stocks at a strike price that is the fair value of the company as of the date of the grant. Stock options grants are not taxable when granted; they're taxable when exercised. So at least you delay any income tax until an exit. And so that's one way that you can incentivize or compensate folks without causing them to incur income taxes. Of course, you know, a stock option is less valuable than a stock grant, but it depends on the circumstances, on the individual's, you know, current financial status, et cetera, on how you get shares to that person. Yeah, here's a quote related to the family and friends. You know, founders are always reluctant to have family and friends, shove a bunch of documents in front of them, for fear of alienating them. But it's just one of those things that you really need to do in order to make sure that everyone understands the risk in investing in a startup company. So we always recommend that all investments be very well documented, and lawyers can help you with that. We do this type of thing all the time. Okay. So you've raised some seed money, some family and friends, maybe an angel. Now you need to raise a significant amount of money to go to the next level. And that can be, oftentimes is, through venture capital. And it is a very time-consuming, labor-intensive exercise to raise venture capital, and a lot of our clients don't understand that from the outset. Particularly in this environment, it's even harder in the last couple of years. The money's out there, but it's taken longer. The terms of the investment are not as good as they were, 2, 3, 4 years ago. It's more expensive to raise capital. But it's doable. It's still out there. The money is still out there. But you have to have a clear message. You have to have a clear presentation. You have to have all your ducks in a row. We'll talk a little bit more about that, about what investors look at when they're evaluating a company. But just know that if you need money in a year, you should start working on it now, because it could easily take that long. Okay, we're talking about importance of agreements again, and this is with employees and consultants. We've touched a little bit on equity compensation, stock versus the options. A good majority of our clients have a stock option plan from the get-go that we can help them with. It provides their employees with, equity participation in the company. Most of our companies aren't paying their employees as much as they would like to. But one way to incentivize them to join the company and to perform is with stock options. Those typically come with vesting as well, over a 3 to 4 year period, have to be exercised within 10 years. But it's a good way to have your employees aligned with the vision of the company. Our employees are all really collaborative, and we don't want to kill them by having them sign a lot of legal documents that place restrictions on them. It's just not a part of our culture we want to create here. Well, we hear that a lot, but it really, again, is important. Let's get the documentation out of the way. Let's get an offer letter signed. Let's get them signed up to the option plan. Let's do that all at once. Let's get it over with. Let's take off the Band-Aid real quick, and then we can get on with the important stuff. But it is something that needs to be done whether it's a part of the culture you want or not. It's something that just really has to be done. Okay, record keeping. We have run into this quite a bit. Companies with good technology, good employees, great team, they're starting to shop around for venture capital, and their records are a mess. I mean, they just haven't. They can't find things. They're filed in different places. Well, venture capitalists pay close attention. Any investor really will pay close attention to how organized the company is. One, because that tells a lot about the management, but two, it makes them nervous that something's out there that neither they or the management knows about. So record keeping is very important. We've had clients who had come to us and said, we're ready to start raising venture capital money. And, we send them the due diligence pieces, and they find out that their records are a mess. Well, it costs them a lot more to have us get them back right than it would be to do the records correct in the first place, and including, involving us in organizing the data room, etc. So, as it says now, pay me now or pay me later. You'll pay me less now and more later. So, just keep that in mind. All right, failure to listen and delegate. So everyone wants to be a jack of all trades, and that's noble, but it's also hard to do, especially in this day and age. And investors don't like it. I mean, they want to make sure that folks are delegated things that they're good at, and the person delegating understands what they're good at and what they're not good at. A lot of times our founders can be very control oriented. They want to do everything. They want to be involved in every decision. They want to micromanage. And that's a tough business to invest in. Investors want to invest in a company that has broad experience from different places, diversity of thought, and so it's very important that the founders understand what they're good at and what they're not good at, and delegate those things that they're not so great at to those that are really experts on those types of things. All right, so generally speaking, how to avoid all these pitfalls? Start with the end in mind. What are you trying to accomplish? Most of our founders, while they want to build something, they are looking at an eventual exit. And so don't think of yourself as a startup. Think of yourself as a company that will grow to be bought. Or if you are intending to continue the company and commercialize the products, we're not a startup, we're a commercial company. Think in those terms. And adopt and promote a company culture of seeking the advice of qualified experts, advisors, including lawyers, but that could be anyone. That's a good way for early stage companies to get expertise in, is to have non-employee advisors come in and help. We've talked about this a lot. Commit relationships in writing, all understandings in writing. Document your financials from the beginning. Get an accountant from the beginning. and just don't bury your head in the sand. These are things that are common for all founders. But what sets some founders apart from others is that they don't bury their head in the sand and just kind of hope that things work out. Hit these things head on. So I know this kind of seems contrary to what we talked about, all these things, but keep it simple. Don't create unnecessary hurdles for investors. Don't give them an excuse to say no. With that, any questions?
Hey, Dan, nice presentation. I appreciate all that.
Oh, thank you, Frank.
I got two questions to kind of start off. One is about, I believe all these people are in the accelerator and the TechTransfer accelerator. So most of us are kind of early on. And a lot of your talk was on setting up a company and the dealings of the company to actually license the technology out of ECU. Question, when you started addressing that, and a lot of your presentation was on things that you do in the company. So I'm just trying to get a balance there.
Yeah, so you certainly have to form your company before you license in the technology, obviously.
Right.
And so that's really the sort of the gating issue for starting the company. So in the accelerator program, tell me a little bit more in that context. So you're developing the technology still within the university confines.
Correct.
Yeah. And so, when you get to the point where Brent and the folks over there are and the individuals are ready to take it to the next step further, that's when you have to start thinking about forming the company. And then, that's where all this starts, right? It doesn't start, 6 months after forming the company. It starts when you form the company.
Right. So there's a lot of details to address on the company side, which is actually separate from the technology, is what I'm hearing. So
Yeah, yes, and yes. I mean, it's separate in the sense that it's agnostic to the technology itself, but it's building the place where the technology is going to reside.
Yeah. Okay. One more small question. You kept talking about record keeping. I could think we're all a mess. So what's the legal, you said maintaining copies of original agreements and all in signatures, and it's not just the agreement, it's signatures. What if you scan those and that becomes a digital copy in today's legal terms, is that okay for filing?
It is. I mean, almost all agreements have some the provision in there about PDF copies, but it's a scanned signed agreement would be sufficient. What we sometimes see is, send us the agreement, and they send us the last Word version they have that's not signed by anybody or signed by one party, and that's where it gets kind of hairy.
Yeah. Okay. And I'm going to jump in one more time, and then I'll try to be quiet. Your data room. When you work with clients, do you have a methodology for setting up a data room for them?
Yeah, we do. We most of our clients, we still use ShareFile. It's very cost effective, and for the purposes of what we're talking about is sufficient. So you can get into all kinds of bells and whistles, and expenses and all kinds of things. But we find that most of our clients that are raising money, share file is sufficient.
Okay. Is that like Dropbox or?
It's similar, yeah.
Okay, thanks. Okay, I'm done. Thank you.
Hi, Dan. Mario de la Fuente, VCU. One thing that I've overheard, and again, this is not my experience, but from the VC side, they tend to see the links to the university as a liability. Is that something that you can speak from experience as being the case? Because what I've overheard is that, you know, the licensing of the IP or the genesis of the startup, having those links to a university sometimes make the process more difficult. Is that just a myth, or?
Yeah, well, I don't know if it's, I wouldn't go so far as saying it's a myth, but that's not been our experience. You know, most of the venture capitalists that we see invest in our companies are very experienced in investing in startups that have university technology.
Got it. And in terms of the friends and family fundraise or pre-seeds that you spoke to, what is the preferred format to do that? A convertible debt or some kind of like smaller equity distribution? Is there a preferred, or I'm thinking about like the down the road constraints that could put into a funding round with VCs, and what would be the easiest, legally speaking, and from the VC appeal?
Yeah, good question. So most of the time we see the friends and family round as a convertible note or a SAFE. And are you familiar with SAFE? It's very similar to a convertible note with some nuances. Some people like them, some people don't. But basically, they're a loan to the company for conversion into equity upon the larger round. And the biggest reason for doing that is early on valuing the company. We know there's value there, but valuing it is a little bit more difficult. And so to value the shares at that point is you know, a lot harder, and even it's always imprecise, but it's even more imprecise early on. And so the convertible note or SAFE, in those with those instruments, you do not have to value the company at that time.
Mm-hmm. Got it. Okay, thank you.
Any other questions from the teams? And Dan, I know we've got a number of people who weren't able to join us, so they're going to watch the slides. So, you know, I would encourage them also to reach out to you. So
yeah, absolutely.
Keeps reaching out. So, yeah, no, I've actually worked with your company for quite a few years, and it's just a great firm to work with for startups.
Appreciate it.
Awesome. So if there's no other questions, we will let you go on. Thank you so much.
All right. Thanks, everybody.
Awesome.
Great presentation. Thank you so much.
Thank you.
Thank you.